Assalamu alaikum, everyone. Thank you for joining today's CAIR on Air. Today we're going to be talking to one of our attorneys about a case that CAIR National is working on. And we have with us our co-host today is Murtaza Khawaja from CAIR Georgia. Assalamu alaikum, Murtaza. How are you?
Wa alaikum assalam, Ayan. I'm doing well. Thank you so much for having me as a co-host today and putting up with me. This is what you get for joining us and helping us on Sunday for our vote-a-thon.
Oh yeah, that's why we have Murtaza on, because he did so well in the vote-a-thon that they had on Sunday. So if you haven't seen that, make sure to go onto CAIR Georgia's page, and it's on ours as well, but check that out. They had a lot of great speakers. And that's a great segue into great speakers. You had a lot of the speakers that we're going to have at our gala on this Saturday. So we're going to have Linda Sarsour, we're going to have special video messages from Congresswoman Rashida and Ilhan. We're going to have a message from Congressman Andre Carson. So if it's going to be, usually this is our biggest event of the year, and it's usually in DC, so a lot of people may not be able to come, but that's why this year, even though we have to do it virtual, for a lot of people it might be even better that way, because now you can still tune in from the comfort of your home. So make sure to go on our pages on Saturday, because we're going to be live at 6 o'clock, and I'm going to put in the comments the registration link for that. But we want to go ahead and get into the topic for today. So Murtaza, if you want to introduce our guest.
Absolutely, Ayan. And I'm extremely excited for this CAIR National Banquet as well. I'm definitely going to be tuning in, and all of you should as well. So I have the distinct privilege today to introduce our first guest. Our guest for today is CAIR attorney Gadir Abbas, who's a good friend and colleague, fellow NBA head. We've talked NBA quite often. We were just doing it backstage as well. Gadir, welcome on the show today.
Assalamu alaikum. How are you, Murtaza?
Alhamdulillah, I'm doing well. Alaikum assalam. How are you doing?
I can't complain. I'm in Chicago in my basement where it's 30 degrees and there's a dusting of snow, but not too bad. And it sounds like in the East Coast, everybody's doing a little bit better off or a little worse off with the amount of snow that they got.
Yeah, it's been well. Yeah, I think in DC, actually, y'all probably have the worst of it.
I'm in North Carolina. It was 70 degrees the other day, so I'm good.
I heard it was 70 over the weekend.
We're doing good.
70 over the weekend, is that right? That is an injustice. That right there.
And speaking of injustices, though, I mean, this sounds like something CAIR attorneys need to get down to. I'm down for us flying out to every place that's 70 degrees in December and getting down to the bottom of this. I'll volunteer myself up first. But we know, Gadir, you've got a lot going on. So we brought you on to talk about one of your cases, Charee Stanley. So this is a case, obviously, that's been going on for a long time. Can you just introduce our viewers to how did this arise? What was the original problem that, gave rise to this case?
Yeah, years ago, Charee, who was a flight attendant, converted to Islam, and then she started learning more about Islam, and then as a flight attendant, she no longer wanted to serve alcoholic beverages to folks on planes that she was servicing, and it just so happened that the particular routes that she did, out of Detroit, there were bigger planes. They always had 2 flight attendants. And so to begin with, it wasn't really a big problem. Her supervisor said, well, why don't you just swap out some of the beverage service? You do the soft drinks, and you just do more of the soft drinks. And when an alcoholic beverage gets requested, you just, send it over to your colleague, and then you pick up some other beverages. And that worked, for a period of time without incident. But one day, one of her colleagues filed a complaint against her, and that colleague complained about 2 things. Complained that she was not serving alcoholic beverages, and that she was reading a book with foreign writing in it. That was the Quran. She would read, the Quran during some of the, downtime that she had on the plane, and this flight attendant, her colleague, objected to it. And unfortunately, when ExpressJet, which was like a subcontractor for some of the airline names that we know of and buy tickets from, when they were put in the position of deciding, do we step up to the plate and give her this accommodation and let her keep the accommodation that she's had, that we've given her, to swap out soft drinks for hard drinks. The company didn't do the right thing and withdrew the accommodation that had been working for some time. And so Charee, unfortunately, like many Muslims, was put in the position of having to decide, is she going to keep her job and violate her faith, or is she going to leave her job and abandon what had been, a good employment for her? And so she chose to leave, and we filed suit soon after. And it's been years and years and years. I mean, this case is half a decade, running, and there were some early setbacks. There was also some early wins, but ultimately. And I think, ironically, what ended up being the problem for us in the lower courts was the collective bargaining agreement. A collective bargaining agreement is the union contract, so workers get together. They say, well, we don't have the bargaining power to negotiate with this $1 billion company, one of us against this $1 billion company. So we're going to all get together, and we're going to, as a working group, as a collective of workers, we're going to negotiate as a single unit with that company. And ironically, that's the issue. The company has convinced two lower courts that the existence of the collective bargaining agreement dilutes the entitlement that Charee and other workers have to the religious accommodations that would otherwise be accorded to her under Title VII of the Civil Rights Act. And that's what we hope, that's what we're seeking review of in the Supreme Court. And we think that it's a very attractive proposition that the collective bargaining is a shield for workers. It should not be something that impedes their ability to access civil rights protections.
And I want to get into some of that a little more, like the actual the steps that you guys took to protect her rights. But before that, I know a common issue is a lot of people, when they hear about this, they push back and they say, well, isn't that part of her job? And I want you to address that part for a moment, for all the people that say, well, she took this job knowing that it was serving alcohol was part of it. That's a very common thing that I've been seeing, like in comments, and whenever she's interviewed, that's something that always comes up. So can you address that for us?
Yeah, and when this case got filed, it was extremely controversial in the Muslim community. I mean, this was a very salient case when it was filed. Lena Musri, our lead attorney, was on The View and CNN, and it was very salient. And in the Muslim community, I think that the feedback was, as you said, this is part of the job. If it's part of the job, why does she get special treatment? And the honest answer is that, well, in many cases, there are plenty of flights where there aren't any alcoholic beverages served, and the majority of flights that flight attendants service, there's only a few alcoholic beverages, and so. And there's no difference really in the work regarding serving an alcoholic beverage and a soft drink and a Pepsi. And so, those are fungible, those are exchangeable. And so, here in this case, and what the law requires is that companies take reasonable steps that aren't, terribly burdensome to allow all of us to bring our faith into the workplace. And here, it's very workable. It's really, really workable. She ends up serving the same number of beverages that she would otherwise serve, but in exchange for not serving some alcoholic beverages, she serves additional soft drink beverages. And I think that's, I think that is, at the heart of the matter here. It would have been very easy for the company to say, that's fine, do more pop, soda, and do less, alcohol. And, that's, in the 60s, Title VII of the 1964 Civil Rights Act, it wasn't passed with, Charee in mind. So, it was primarily seen as a way of ensuring racial equality in the workplace, prohibiting racial discrimination in the workplace. But, the folks, the civil rights movement that backed that law had the foresight to create protections for religious folks that benefit people like Charee, and I think a way that was probably unimaginable back in the 60s. And it does reflect that in the United States, the laws about religious liberty are very good. They're very strong in a way that makes the U.S. stick out and stand apart from, the United, European Union countries or even Canada. And so that's what the law is, and we think that it should be applied.
Sure. Good. I think you hit the nail on the head there. And I actually we do want to get into where you started the legal action and where we are now in the case. But I think one thing for us to stress upon for our viewers is the strength of religious liberty laws in the United States. And what is central to this case is the fact that she asked for an accommodation. And if you can just go briefly into what standard we look into for when you're making a request for a religious accommodation, when does it actually have to be granted by your employer? Because I think our viewers would be very interested in hearing about that, not only for insight on this case, but for those who also might be potential victims of religious discrimination in their workplace.
Yeah. One of the requirements of this federal law is that your employer knows that you're seeking an accommodation, and you're seeking an accommodation for a religious reason. And so sometimes that's, the standard uniform policy, does not allow people to have, a head covering like a hijab or a kufi. You would want to request, from your employer an accommodation that would allow you to deviate from that uniform policy. It's always best to make the accommodation request in writing, by email. Some bigger companies or more sophisticated companies certainly have, forms regarding these accommodation requests. But you need to make the accommodation request to your employer, and includes, this is what I'm looking for, and it's for a religious reason. And sometimes, the accommodation is needed because it's, a workplace, let's say like it's a security company in a part of the country where there just aren't many Muslims. And that security company says, no head coverings. We've seen this, a bunch. Or, you need to be clean shaven. We've seen that a bunch. And they're not really thinking it through in terms of its implications for Muslims or for, people that might not be Christian. And so many times the response from those kinds of employers who craft policies that don't allow Muslims to bring their faith in a particular way to work, maybe they do it unintentionally. And so that's, I think, why the request, practically speaking, is important. But it's also important because if it doesn't work out and you're forced to, leave work because they won't, you're a salaried manager and they won't let you leave for 45 minutes every Friday to go to Jummah during your lunch break, or, you work at a factory and they won't let you break up your 30-minute break into two so that you can do Dhuhr and Asr, and you leave work and you come to me or you come to Murtaza, having a piece of paper somewhere that says, I made this request on this day changes the entire complexion of a case. It's too often we see that the response of an employer in litigation regarding whether an accommodation was legally required is, well, we never got the request in the first place. We never denied it because we never got it. And, it's really hard to argue with paper. And so, making that request and making it in writing is best. I think the complicated question, and the question that I think is really fraught for a lot of Muslims, is, well, what do I do, during an interview? I don't even have the job yet. And, what if it becomes clear to me that I need an accommodation, while I'm interviewing? And this has happened, before, where, and I think a lot of Muslims struggle with this, and, what I always say is, if probably, if you're visibly Muslim, or if, you're Muslim, by your name, or you're Muslim, your Islam is evident, in your resume, you're better off, letting the employer know what you need first, rather than, getting in there and making requests later. But it's the same kind of situation. If you interview for a restaurant, and a lot of restaurants will have no loose fabric kinds of requirements, and a lot too often, even with tight fitting hijabs, we see employers interpret those as loose fitting fabric because they don't want it there. But you're better off asking and making clear on the front end, and then then dealing with it later.
Something that I'm noticing in the examples that you're bringing up and in Charee's case, the accommodations that they were asking for, I know that when we talk about them, we usually label them as reasonable accommodations because they're things that don't interfere with how they perform their jobs, right? So I even heard her in an interview saying that this isn't an essential part of her job, serving alcohol, and how you just mentioned people taking breaks to pray. It's not something that would interfere with how they perform. It's just like someone taking a lunch break or a smoke break, right? So I just think that that's I think when those come up, when that comes to light, it just shows how it is like it's a religious issue, right? Like it's not, if we're allowing the same accommodations for people that aren't saying it's for religion, then that's kind of what makes it obvious, like why it's an issue. And
yeah, and we always do that, in our cases. One of the strongest points that we can make is, are they treating secular breaks?
Mm-hmm.
Breaks taken not for religious reasons, like smoke breaks, bathroom breaks, are they treating those breaks differently than prayer breaks? And almost always, they are. If there's an accommodation issue, they're letting people go to the bathroom. They're letting people smoke. They're letting people make phone calls when they need to, and it, just below the surface of every denied reasonable accommodation is some animosity towards Islam. It's always, lurking, right underneath. And I think that's just, part of these kinds of cases.
So what are we hoping for in Charee's case? Like, what is the best possible outcome now, like where you're at now in the case?
Yeah, unfortunately, if we win at the Supreme Court, we don't win the case. If we win at the Supreme Court, it goes back down to the lower court, to the Eastern District of Michigan, in Detroit, for a trial to determine whether or not the accommodation was reasonable, or whether the accommodation created an undue burden on the employer. I mean, that's what we want. I mean, we think that the strength of the case is how easy it would be for the employer to accommodate Charee here. It would have been really, really easy for there to be what would essentially be a one-to-one beverage swap, alcoholic for soft drink beverages, with both flight attendants still doing a shared amount of the beverage service. And we feel good about our chances at the Supreme Court because we're not really relying necessarily on, Sotomayor and Kagan. What gives us a lot of confidence and what, pushed us to file in the Supreme Court was Alito, Samuel Alito's concurrence in the Abercrombie case. The Abercrombie case was, like a really, a really significant employment discrimination case from, many years ago, 2014, 2015, where a young Muslim sister wanted to work at Abercrombie, but wanted to wear hijab. And initially they said, yeah, that's fine. You can wear hijab, but it just has to be solid colors and go with whatever their color scheme is. And she said, that's fine, until like a regional manager came and said, absolutely not. Your hijab is violating our look policy. And they fired her. They, made her choose between her hijab and employment. And Abercrombie, which is like a vicious, bigoted company, rather than settle it, rather than just adjust their policy, they really, pursued a scorched earth approach to win in court. And they lost overwhelmingly in the Supreme Court, among the conservative justices and liberal justices. And Alito went further than a lot of the others in minimizing, in interpreting the federal law in a way that made it easier for employees to be entitled to accommodations and made it harder for employers to show an undue burden. And that's, I think, like just a globally important thing for folks in the Muslim community to be aware of. There really is like a scrambling of the political spectrum when it comes to religious liberty issues, where it doesn't always fall so neatly. The liberals are good for us and the conservatives are bad for us. There is there is trans ideological support for religious liberty in the U.S. And there is like a willingness among conservative justices to go out on a limb and articulate broad, robust conceptions of religious liberty. And that's what we're hoping here. It's kind of a twofer. It minimizes Charee's case, narrows in some ways the scope of a collective bargaining agreement, which has some conservative appeal, while interpreting more broadly the scope of religious protections given by Title VII. At least that's the theory. We'll see, I think, in a couple months, where the Supreme Court comes out on it.
And Ghadir, one of my last questions was, is this a common issue? And I think we've pretty much covered that, is even with the last example you just gave. This is unfortunately, like, we see this a lot. So if there's anything else that you want to add about like what concerning that, or about what people should be doing.
Yeah, it's really, really difficult to be an employee in a workplace that is not friendly to Muslims. And for Ayan, myself, and Murtaza, we have it easy. I mean, we work for a Muslim organization. We don't have to explain, our religious holidays to anybody. If we don't answer a call because we're praying, mashallah, that's the response of our colleagues. If you're not in that kind of workplace, and almost all Muslims aren't, when you get discriminated against, everybody in our community has an interest in the outcome of what happens to you. Everybody in our community benefits from any employee fighting for their religious rights. It's the most common thing in the world for a Muslim to be the first in their company to demand this, to fight for that, and for others after them, other Muslims, to come after them and benefit from that struggle. And so, for folks that are struggling with workplace situations, Murtaza and myself, we have our price is right. We're free. You give us a call. That's what we look forward to. We want to help you navigate those kinds of situations, and if need be, we're willing and able to fight these cases for years and years and years in courts. This case started in Michigan, it went to an appellate court in Ohio, and now it's in the Supreme Court in DC. We did depositions in Atlanta, all across the country, to pursue this case, and that's the kind of persistence we bring to a struggle. So it's our honor to help you in those things.
Absolutely. Gadir, I just wanted to add one thing to it. You mentioned it earlier, and I absolutely want to stress this. Please document any request you have to your employer, and any subsequent denial or complaint or grievance you have as a result of that. Make sure you document it. Make sure you have that documentation. We'll represent you regardless, inshallah, but this will give us so much more to be the best advocate on your behalf and make sure that there's the best possible outcome that there can be.
And Nazir, when you were talking about like us making those requests, like holiday requests, because you might be with an employer who's not Muslim and doesn't know, it just reminded me of when you're in school and you have to ask, like you're asking for the day off for Eid, and you're like, it might be Thursday, it might be Friday, I'm not really sure. It like depends on the moon. So I can imagine it's like even harder at a workplace because like the stakes are a lot higher.
Yeah.
But yeah, alhamdulillah for being with other Muslims, and everyone here understands, and inshallah we get to a point where the non-Muslims understand, the moon cycle.
Yeah.
So with that, I think we're out of time. Unless you guys want to finish your NBA discussion, we're done with the questions we have for you, Libyan.
Gadir, prediction for the finals. Let's hear it. The people want to know.
I think it's very clear that the Lakers are going to repeat, and it's not going to be competitive. I think that Anthony Davis can get better. LeBron, is probably going to get better as well, and it's just going to be a bloodbath, through the finals. I don't see it being competitive this year.
Who's coming out of the East?
Wow, who's coming out of the East? I think Miami. Miami got a little bit better. They get Jake Crowder. I think they got Jake Crowder. Excellent role player. Bam is going to be better.
Bam is incredible.
Than he was last year. Yep, I think they got it. And another year together, just the chemistry. The chemistry is going to be better this year than it was last year.
Yeah. I think we should just have you guys on there. We're going to have you guys for another show. We have the whole 30 minutes. Okay. Thank you, everyone, for joining. Tune in for the annual gala on Saturday. I've left the link in the comments section, so you can register through that. Inshallah, we'll see you there, and we'll see you for the next CAIR on Air. Assalamu alaikum, everyone.
Assalamu alaikum.